So it's now my pleasure to welcome the Attorney-General for Western Australia and the Minister for Commerce, the Honourable Mischin, MLC. I'd like to first acknowledge the tremendous contribution of WA Government that they've made to this conference through the Attorney-General's portfolio in both assisting with the organisation of the conference and also signing up as a platinum sponsor. This has really enabled us to put together a very stimulating program which will provide those researching, working in the field in the areas of victim support with a better understanding of current issues in the field and hopefully provide a few ideas of interesting discussions that will fuel some thought when you go back home. To give you an idea of the attorney's background, Mischin graduated from the University of Western Australia with bachelor's degrees with honours in law and jurisprudence in 1982, and he practiced in private law firms until 1985, at which point he joined the Crown Law Department and began to specialise in criminal law. Completing almost 24 years as a government lawyer, Mr Mischin was a senior state prosecutor with the West Australian Director of Public Prosecutions prior to entering the West Australian Parliament in 2009. He's been the first practising lawyer with substantial experience in criminal law to be appointed to the role of Attorney-General. He's served in government as the Parliamentary Secretary to the Attorney-General and Minister for Corrective Services Minister, the Honourable Christian Porter, MLA. Mr Mischin continued in this role when Mr Porter assumed the position of Treasurer in December 2010, in addition to his Attorney-General duties. In June 2012, Mr Mischin was appointed as the West Australian Attorney-General. Following the March 2013 state election, he added the portfolio of commerce to his ministerial responsibilities. It's now my pleasure to welcome the Attorney-General of WA, Mr Mischin.
Thank you, Adam, and welcome, ladies and gentlemen, delegates to the 15th Annual International Symposium of the World Society of Victimology. It's a great pleasure to be here and have the opportunity to address you on the first full working day. I've got to say that being the Master of Ceremonies is possibly one of the most thankless tasks in conferences. One wonders whether Abraham Lincoln would have delivered quite that edge with his Gettysburg Address if he had to tell people in the lead up as to where the toilets were and where the smoking and non-smoking areas were to be found. But it is also one of the most essential jobs in one of these conferences in order to keep things running on time and in accordance with the schedule. And I should start, I won't go through the list of distinguished people that are here today, but I should acknowledge the work of the event organisers, the World Society of Victimology to start with, Victim Support Australia, Angel Hands Incorporated, and the Australian Institute of Criminology. It always takes vision and a commitment to embark on a long journey involving a great deal of work to make these events possible, and I thank the organisers for their preparedness to undertake the task. I'd also like to acknowledge Mr Abdul Haris Semendewi, Chairperson of the Indonesian Witness and Victims Protection Agency, who has been here on the invitation of the Commonwealth Government. And I hope that he finds his trip to Western Australia productive and there'll be some cross-fertilisation of ideas as to how we deal with the challenging task of managing victims in our criminal justice system. The overarching theme of this symposium is victimisation, justice and healing, challenging orthodoxies. The theme is calculated to provide a focus on sharing best practice, emerging responses and critical reflection on the discipline of victimology. The impact of crime on any given victim ranges from loss of a loved one or loved ones, to temporary or permanent injury, to loss of income, and to feelings of sadness, guilt, disempowerment and loss of security. Good practice and just common decency tells us that responding to victims of crime with compassion, with empathy and respect, and providing them with useful information about the supports and services available to them can make a difference. It can also be an important step towards them regaining a sense of control that has been lost through the offences perpetrated against them. The obligation upon government, therefore, includes not only the detection of crime and the prosecution of offenders and the punishment and hopefully rehabilitation of offenders, but also support for citizens who are victims of crime. Recognition of the latter has evolved over the past several decades, perhaps starting in Western Australia with the Criminal Injuries Compensation Act of 1970. But monetary compensation, while helpful, is not itself sufficient or in many cases an appropriate or suitable answer to the challenges that victims face. When I first joined the Crown Law Department in 1985, victims had no formal recognition in the criminal justice system. It's not to say that services and support were not provided for them or that they were not routinely assisted through the daunting process of a criminal prosecution by prosecutors or by investigating police officers. But the assistance was informal and effectively ended with the finalisation of the legal case. The change in that aspect of the criminal justice system is one of the most radical that I have seen in the past quarter century. Some of the most important developments in Western Australia were overseen by former Liberal Attorney-General, the Honourable Cheryl Edwards, which included the passage through the Western Australian Parliament of the Victims of Crime Act of 1994, with its charter of what victims could expect from service delivery and justice systems, the establishment of the Victim Support Service within the Department of the Attorney-General. Last week was in fact the 23rd anniversary of formal Victims of Crime services in Western Australia, and the creation of the Child Witness Service, also within the Department of the Attorney-General, which is highly regarded as the benchmark for child witness support in Australia. There has been for some time in Western Australia a body known as the Victims of Crime Reference Group, comprising government officers and members who have lived experience of crime or who are representatives of victims. This group advises me on victim of crime issues. In 2011, we breathed new life into this Victims of Crime Reference Group. One of the subsequent recommendations of this group was the establishment of the Office of the Commissioner for Victims of Crime. Our government's response to the recommendation was the appointment of this state's first Commissioner for Victims of Crime, Ms Jennifer Hoffman, in July 2013. And she is with us today and at some point will no doubt be able to tell anyone about the work that she has done and the extent of her remit. This is a significant milestone in the progress of victim support in Western Australia. The Commissioner works directly with many individual victims of crime, not only to assist them in their particular cases, but to understand the needs of victims of crime generally. She's also conducted outreach visits right across the state. This has led to a top-down, grassroots-up method of policy development, where the experiences of individual victims can become quite rapidly, in terms of government policy development, the source of reform. Some of the initiatives that the Commissioner has been involved in during the past 2 years include, in no particular order, but arranging for our parole authority, the Prisoners Review Board, to receive and so be able to take into account much more information from victims of crime when a prisoner is being considered for parole. Processes are now in place so that victim impact statements made to a court can be automatically provided with the victim's consent to the Prisoners Review Board. And I'm pleased to see the chair of our Prisoners Review Board and our Mentally Impaired Accused Review Board, the Honourable Judge Robert Cock, QC, who is here today as well, and I'm sure will be able to assist you with advice as to how he goes about his job. I'm pleased to say that the relationship between our Commissioner and our Chair is very close, and there has been an enormous amount of cooperation and assistance in developing processes that don't require legislative change, but simply addressing administrative issues to facilitate the way that victims can be dealt with and their concerns addressed. The strong partnership between the Commissioner and the Prisoners Review Board has also led to a change of transparency measures around parole processes aimed at informing victims of crime, including making available to the public the policy manual used by board members, access to inspect board files, and enhanced parole information for victims of life-term prisoners. In 2014, there was conducted a successful trial of a victim information card, which aims to greatly improve the feedback from the Western Australia Police to victims of crime and to provide victims with information about how they can get assistance and support. A further initiative was a wide range of victim information processes that have been put in place, including a practical online Your Voice video series. These videos have already helped hundreds of victims of crime, including children, to navigate their way through the criminal justice system and to learn of support services available to them. The Western Australia Police have been very helpful in allowing the use of their social media facilities to highlight the availability of this victim of crime information. And otherwise, there have been recent changes to practice in the District Court of Western Australia, our principal indictable crime court, which means that victims of crime now do not have to demonstrate exceptional circumstances in order to be permitted to read out their victim impact statement in court, rather than the victim impact statement being provided to the court only in writing, as was previously the case. The Supreme Court of Western Australia also has been involved in reforming its processes. That court is the forum for dealing with those crimes for which the maximum penalty is life imprisonment: homicides, arsons and the like. And it has also recently issued a practice and procedure note regarding victim impact statements, the first mention of victim impact statements in the practice directions of that court. Otherwise, the Commissioner has worked with a leading non-government organisation which provides services to child victims of sexual abuse to establish a 12-month trial of co-located police and child protection staff at a centre to be a one-stop shop for the justice system, government services and treatment options for abused child victims. This is an extremely important initiative which will be studied closely over those 12 months by researchers, hopefully to provide an evidence base for its refinement and expansion. Victim of crime services within the Department of Corrective Services, namely the Victim Offender Mediation Unit and the Victim Notification Register, have also been through a reform process with the Victims of Crime Commissioner, with results including an innovative system for applying protective conditions to parole, where those protective conditions automatically apply unless a victim chooses to opt out of having them. Joining up is a strong theme of the work of the Commissioner's Office, with one example being the encouragement of a mentoring and professional development relationship between those involved in victim of crime mediation in the Department of Corrective Services, and joining with some of the most experienced mediators in Western Australia, those of our State Administrative Tribunal. In addition to the continuing services for victims of crime, our government has enhanced the funding of victim of crime services. In 2013, the government announced the allocation of $3 million over 4 years to expand support services for victims of crime and family violence in regional areas. Also in 2013, recurrent funding of $600,000 a year was allocated to establish and run a metropolitan legal service for Aboriginal victims of family violence. In addition, $3 million from our government's Royalties for Regions fund pool was allocated to provide culturally appropriate support for Aboriginal victims of crime in regional and remote communities, with services funded by this grant ongoing. These funding initiatives, of which the government is proud, are only part of the story though. For instance, in 2013-14, over $34 million was awarded to victims of crime in Western Australia under our Criminal Injuries Compensation Act of 2003. Further, non-government victims of crime services are eligible for funding under the Criminal Property Confiscation Grants Program. That money is generated from property seized from offenders, primarily the proceeds of drug trafficking or property of drug traffickers, and provides grants for victim programs and other crime prevention work such as drug and alcohol programs. Otherwise, Western Australia has internationally recognised purpose-built crime victim and remote witness facilities integrated into its court building program. The District Court of Western Australia, housed in a building in central Perth, opened in 2008, led the way with victim and vulnerable witness facilities designed in consultation with members of the Victims of Crime Reference Group. In the past 2 years alone, court and justice complexes with dedicated state-of-the-art crime victim and remote witness facilities have been opened across the state, with the $52.5 million Carnarvon Courthouse, the $41.8 million Kununurra Courthouse, and the $41.7 million redevelopment of the Kalgoorlie Court. Also part of the picture are recent new programs funded by the government, which include support for victims of road trauma-related crime and support services for the elderly who are suffering abuse. I should add, in just a context of court design, is how much can be achieved by some thoughtfulness as to how those are laid out. Australia's had some, Western Australia, over 150, close to 200 years of experience in designing courts, and has done a better or worse job depending on the circumstances. But the separation, for example, of victims and witnesses from areas that may be frequented by the accused in crimes and their families and supporters is an important aspect of court design that is often overlooked for purposes of expediency and cost measures. The Kalgoorlie Courthouse and others are very sensitive to those sorts of issues, and work has been done without making things too isolated to at least address the issue that people may not be comfortable with mingling with the families and supporters of those who are accused of committing offences against them. The scale of the undertaking across government to directly support victims of crime includes many agencies that do not have victim in their office title. For example, we have the Family and Domestic Violence area in the Department for Child Protection and Family Support, working with Western Australia Police and non-government groups as part of the Family and Domestic Violence response teams. The Family and Domestic Violence Service Delivery area generally involves significant government resources, including in 2014-15 about $21 million to fund 37 accommodation and support services for women and children escaping family violence, and $4.9 million for 22 family violence counselling, advocacy and support services. The Domestic Violence Legal Unit of Legal Aid Western Australia also provides specialist legal assistance for victims of family violence. We also have the Sexual Assault Resource Centre within the Department of Health to provide medical, forensic and counselling services for victims of sexual assault in collaboration with the Sexual Assault Squad of the Western Australia Police for victims who choose to report this crime to police. We have the Protective Behaviours Unit in the Department of Education working on getting the message out to children in schools about personal body safety. And we have the community engagement area within the Western Australia Police itself. This office works on a range of victim of crime initiatives within policing. So where to for Western Australia in the future? The subject of family violence has been particularly prominent in the last 12 months in the Western Australian Government's work for victims of crime. In 2013, I asked the Law Reform Commission of Western Australia to examine the issue of family and domestic violence laws in Western Australia and to recommend ways victims could be better assisted, and the final report of the Law Reform Commission was published in mid-2014. I'm pleased that we've now commenced a comprehensive reform program in Western Australia in relation to family violence responses in our justice system. Earlier this year, it was announced that the government will overhaul violence restraining order legislation to introduce specific family violence restraining orders, or FVROs, to separate them from the general violence restraining orders that may cover circumstances beyond a domestic relationship. These FVROs will adopt a more modern definition of family violence, moving away from the concept of a victim having to provide evidence of an act of abuse and towards focusing on behaviour intended to intimidate, coerce or control. The courts will be required to adopt a risk management approach to granting VFROs, considering information from a variety of government agencies to not only ameliorate the risks to victims, but to address the behaviour of the perpetrator. The courts will be able to order conditions specifically tailored for family violence, such as mandatory perpetrator behaviour change counselling. I've also recently announced a new process for tackling family violence in our magistrates' courts, the courts primarily responsible for issuing and enforcing violence restraining orders. Rather than continuing to focus on offenders through a court diversion program, we'll be mainstreaming family violence cases in courts, but in court lists which will have victim support workers in attendance. This is a model which is to build over time, with the initial court lists to prioritise criminal charges stemming from breaches of violence restraining orders and serious assaults, which occur in family violence circumstances. Another forthcoming legislative initiative of the government is the creation of a new category of serious violent offender to enable such offenders to be the subject of supervision, including GPS tracking and monitoring, for up to 2 years after they have completed their sentence and would ordinarily be discharged and at large without any supervision or restraint. Serious family violence offenders and arsonists will be able to be supervised in this way. Family violence is not capable of easy solutions. The complex dynamics of familial and personal relationships, combined with learned behaviour and cultural norms, means that there's no easy or quick solution to the circumstances in which people find themselves, victims or perpetrators. It'll involve generational change and will no doubt involve much trial and error on the part of government and service providers. But as with many forms of behaviour that we once thought either acceptable or intractable and have now been changed or in the process of change, I am confident that with commitment and a willingness to learn, we can eliminate this social scourge. And I look forward to seeing what emerges in this area, as well as how to improve the lot of victims generally from this symposium. I wish you the best for a terrific symposium. I hope that you take advantage of this outstanding opportunity to speak to fellow practitioners in this area, to learn from them, to share your experiences, your expertise, the experience you've won the hard way, for mutual benefit. I'm hoping for great things out of this, to learn what can be done to help shape policy development into the future. And I hope that you take away with you from this conference not only new knowledge, new ideas, but also new contacts across the field that you can use. It's very helpful, if only just to meet other people and realise that you are sharing the experiences and the stresses and the troubles that you are facing are not unique to your circumstances, and that trouble shared is trouble halved. I also know from my previous life as a barrister that if things go smoothly on the day in court, it's because a lot of work has been put in behind the scenes. And I'd like to thank those who have been involved in the organisation of this event to make it run smoothly and for your benefit, to maximise your enjoyment. And I hope that you have the opportunity to see our city, those of you who are from interstate or out of town, or from indeed overseas. And thank you once again to the organisers and the World Society of Victimology for the efforts that have been put in. I'm proud to be able to open this conference in Western Australia. Thank you.